invention and look at that document and extract the IPC code. And try to check if your invention falls under that IPC or CPC. If you found the appropriate IPC or CPC, you can rerun the search and include the IPC or CPC you have searched. So it is also important to make a documentation of your search. This is there is a document what is called patent search report. So I will it will be used if there is a activity on patent search. So based on the steps we discussed, there are a lot of information are being considered. So that's why this documentation is really important. This is very helpful when retrieving data. If there is no documentation, one may execute again the search and it would be a waste of time. So on your documentation, you have to note the date and time of the search, record the classifications used, list the databases used, jot down patents and application number, and keep full text copies of the most relevant prior art. So, like I said earlier, there is what is called a patent search report. That is a consolidated form where you can input the essential information on how did you execute the patent search. That includes also the number of hits in every search string you inputted in the databases. So if the search if a particular search string has a hits of 10,000 results, that may be a very broad result, and you may also input it to the patent search report. Or if you have a search result of 200 hits, that may be good enough to have a review if your relevant document is within that 200 hits. So so that's the importance of documenting the search, no? So I think that is all for the pointers as well as the search strategy. So I want also to emphasize that doing patent search is really important. The main goal here is to find the closest prior art or document so that you can decide if your invention is worth to pursue for patent protection. Like if you found a patent document that describes similarly to your invention, then you have the idea that the chances of having the patent grant may be low or be denied by IPOPIL. This will eventually avoid you from waste time, effort, or money. Also, if you found a closest prior art and it seems similar to your invention, it does not mean that you have to abandon or give up your invention or research. Of course, you can do reconfiguration, for example, or further scrutinization of your invention to make it new or patentable. So that's another purpose of patent search. So I think that's all I can share. So I hope everyone here at least get the idea of patent search. So thank you. Thank you for listening.
Thank
That's
you,
all.
sir.
All right. Thank you so much, Engineer Lawrence. Thank you, sir, for all the several I'm sorry, for all the several insights that you have shared with us. It was very constructive and informative, sir. Thank you so much, sir, for being one of our speakers today. So, while waiting, guys, for the next part of the program, let us watch this video together.
Samsung v. Apple is a long-running dispute between two main mobile phone manufacturers. These two companies have been fighting with each other over various patents that they hold all over the world, with Apple winning some and with Samsung winning some. But Supreme Court is going to focus on just one issue: whether Samsung's infringement of the way Apple's phone look should be much lower and be reduced to limit them only to the value of a particular design that Apple came up with. There are generally two types of patents. One is called utility patent and one is called the design patent. A utility patent is one that is meant to cover the way things work. Design patents cover the way things look, irrespective of how they work. It's purely ornamental. Design patents are meant to cover these ornamental features that do not affect the utility of a particular device. Currently, it's only those patents. It's not the utility patents issue. The court is concerned about whether or not Apple has really exclusive rights to fairly small features. These are not fundamental, groundbreaking things. Whether or not by having patents on those things, they can essentially bankrupt an entire line of Samsung products. Apple prevailed at a jury trial. A jury concluded that Samsung's Galaxy devices infringed some of Apple's design patents and awarded them a judgment in the amount of roughly $1 billion. Eventually, the case was appealed to the United States Court of Appeals for the Federal Circuit. Unfortunately for Samsung, the statute by its language is fairly clear. It does say entirety of the profits. Section 289 of Title 35 of the United States Code says that when a design patent is infringed, the infringer is liable for the entirety of his profits. The section is actually fairly clear, and we can certainly debate whether or not that's a right decision or a wrong decision for matter of economics, fairness, incentives, and so on. Nonetheless, that's what Congress said. Therefore, Samsung was liable to figure out how much money they made on sale of their Galaxy devices and turn it all over to Apple. It's going to take some effort by Samsung to convince the court that the statute is either not as clear as people think, or at least doesn't make sense in a modern economy. Samsung's argument is that people were not necessarily buying Samsung because it has rounded edges and a button at a particular location. And even if they've infringed those patents, according to Samsung, they should pay something, but they should pay only for the value of those particular features. And of course, the value of particular features is not very high. If Supreme Court agrees with Apple, then Samsung will pay its $1 billion judgment plus whatever interest has accrued since then. If Supreme Court agrees with Samsung, then the case will be remanded back to the trial court for additional trial, not on the issue of infringement, because that's already been settled, but on the issues of how much that infringement actually worth under the rule the Supreme Court will announce.
Hello everyone, thank you for still staying and joining with us today. So we are encouraging you all to feel free to message in our chat box if you have questions, able for all of us to address your questions immediately and effectively. So are you still there, guys? I hope I can see your faces and can hear your voices, because we are still not done in our program. So for the next part of the program is the open forum or the Q&A towards our speakers. So if you have still some questions, feel free again to chat in our chat box. So I hope that you are doing fine despite of the cold weather. So guys, are you still there? Can someone answer my question? Are you still there? Are you still listening with us?
Yes, sir.
Yes. Yes.
Yes.
So I hope you're doing fine. So are you all excited for the next part of the program? So let me know if you're ready. So enable for me to know, please give me a like reaction to able for me to move for the next part of the program. All right, I think we're ready now. So for the next part of the program is the open forum or the panel discussion or question and answer portion. And also to our speakers, engineers, and professor. Sir, pwede ra daw mo, sir, na kanang mag-follow up answer sa question, sir, or kinsay gusto mo answer, sir. So I guess that our speakers are ready to answer your questions. So let's start. For the first question is, next slide please. This question is for Professor Shudad, for Professor Kenneth. So can the Philippine government use the patented invention without authorization of the patent owner?
May I clarify what does this mean? Like which who in the government?
Yes. May I request Marjan to please help me for this matter? The question is, can the Philippine government use the patented invention without authorization of the patent owner? May I request anyone from our...
Any branches sa government siya?
Yes, sir. Yes, sir. Yes, sir.
So parang there is an individual who owns the patent. Tama? Then can anyone in the government use the patent without its authorization?
Is that right, Ate Shiva or Marjan? Can you... Yes,
Yes,
thou, sir.
Because the question is somehow ano ba? Kasi obviously if there is a patent owner, it is the government that grants the right for the patent owner to exploit its rights, economic rights in the patent. So clearly, I think any form of violation, whoever is doing it is a clear violation of the law. So parang ayun. Siguro maybe we could rephrase a little bit on the question. Maybe there are cases when the government decides to use the patent, of course, with proper documentation and courtesy. I think it's just right that they will inform the owner, the original owner. But yeah, there are times when the government can actually use certain technology for public use, especially relating to health, something like that, especially like pandemic. For example, there is a technology developed by someone and there's a pandemic that let's say, for example, at first the technology was utilized by the patent owner, of course, for business something. And later on, the government realizes that it is the best, or perhaps even the only way, to solve a national level problem. So I think the government has also somehow, that power to make use of the patent. But for whatever reasons, petty reasons, it would appear as a violation, especially without authorization. Did I get it correctly? I mean, the question correctly, I hope.
Yes, sir. Thank you, sir, for nailing the question very well. I guess we're ready to proceed for the next question.
Sir? Na ako'y question, sir ba?
Go.
Kaning naa na ba'y case nga ang government mismo ang naka-violate kay nigamit sila og kaning kuan kanang patented na innovation, sir.
In the Philippines, no, none that I know. Because actually we somehow even the Filipinos are just starting to engage themselves on this. And again, clearly, the government is the one granting the owner the right. So I think it would be odd na the government will violate its own laws, di ba?
Ken, just
Yes, sir.
yeah. So this is a very good question, no, because maybe she has an idea about government taking advantage, no, of the patent. I just want to add that based on the IP code of the Philippines in section 41, I think the Philippine government actually can get the patent and actually make use of the patent, no? But there are certain cases that mentioned earlier, no? So one is national security. So public health, no? So COVID pandemic is mentioned. So I think these are the exemptions, no, to the rule that the government can actually make use, no, of this patent. No? So that is provided by law. No? So in case of national emergencies, no, so the government can actually use the patent, no, to really address the situation we have in the country. So for that reasons, no, in terms of the so that's stipulated in the IP code of the Philippines. So but then if the situation is not really parang not emergency, or it's not even
Not
required, so
reasonable.
yeah, so it doesn't make any sense, no, why the government, like for example, the government would commercialize the technology in behalf of the patent owner, so it doesn't make sense. So basically that is not allowed, no. So by law there is a specific terms there when exactly the government is allowed to use the patented technology. So national security, health reasons, mga public emergencies, no, because basically to address the situations, no, so for public good as well. So basically those are exemptions.
Siguro to
All
add,
right. Thank you
Sheba,
so
sorry.
much, Engineer Jeffrey and Professor Kenneth, for answering that question. So I guess we're ready to move to another question. So the next slide, please. So this is for Engineer De Liosa. So the second question is, what are the remedies can government offer to patent owner in cases of patent infringement?
Yeah, it is also thank you for this question. So it is also provided by law, no, that the government will offer remedies, no, to those people who are like offended because their patent are infringed. So basically, just I think this was mentioned yesterday. No, I think Kenneth or Lawrence during the talk on especially we mentioned about the case of Kenneth Cobonpue, again Kenneth. No, so his creations, intellectual creations, no, so that is related to industrial design. It's not just about patent, no, but all forms of IP that is protected by state or we've been given with the IP rights. No, so the government can actually like settle this in behalf of the patent owners. So for the case of it was really evident in the case of Kenneth Cobonpue that the government, like the NBI, the DTI, and the IPOFIL, they went after those patent infringers. They collected all the creations, the copycats from the original design, and then they actually like impose fines and sanctions, and then they actually closed down those stores, and then they actually burned all those copycats. So that's what happened during the situation. So basically, just like what happened to the video, the case of Apple and Samsung. No, so basically at the start, so they will go for settlement, no, before reaching really the case to court, no, so there will be litigations. So settlements first, if both parties can agree to the amount of damages that was incurred, not to the owner of the patent. So they will try to establish the figures, no, if the money is the main issue. So they would agree on certain amount based on the value of the damages that was incurred in terms of infringing the product. No, so if they reach a settlement, then the other party will have to pay for it. No, so IPOFIL will mitigate or will address this, try to address this problem before the both other parties will go to court, because we know that when we go to court it's very expensive. Lawyers are very expensive. Law firms are very expensive. No, so we go for settlement first. No? So there are cases actually, no, like the suka pinakurat. So this might not be immediately patent as an example of patent, but they're related to IPs that really like went to kind of settlements, no, before it was like brought up to courts. In the US, there's so many stories in the US, but not a lot in the Philippines.
All right, I'm speechless, sir. And thank you so much for addressing that question, sir. So I guess we're ready to proceed. So for the next question is, next slide, please. So for the third question is for Engineer Lawrence.
Yes, sir.
So the question is, can an interested party file an action for the cancellation of a patent?
So, na nag-question sa ako. Hello? So, can an interested party file an action for cancellation of a patent? So there is a sir, I think in my knowledge, no. So there are possibility na a person can request for cancellation of a certain patent. That's if he have the evidences, like for example the like the prior art, or let's say the criteria of the patentability. Uh, if it is not novel, if he has the evidence that a certain patent is not novel, let's say he has found something prior art that is 12 that is not, kumbaga dili siya kuan bitaw, naka-destroy sa novelty sa invention. So that's a legal that's a reasonable reasonable action niya. You can file a cancellation for that patent. So there are also cases like kasagaran nga mag away-awayan kay kanang mga competition between mga duha ka company, like kanang sa itong state ni Sir Jeff ganina nga Samsung ug Apple. So na sila yung mga kuan ana nga ang patent sa Samsung is already kuan na sa Apple or ginana bitaw. So it is possible.
All right, thank you, sir. And now I would like also,
if may I substantiate that,
Yeah.
sir?
Yes, sir.
Answer.
Yes, sir. Yes, sir.
Actually, in a filing of patent, there's a certain process that your application will undergo. It's actually not quick to have your patent application granted. It takes quite some time, and part of the process is actually the publication of your application. It will be published to the public that you are applying this kind of technology, so that anyone who has the interest, actually this one, the interest to question or to nullify your application, can do so. So that there is a certain period in the process, in the application process, where this thing happens, no? Kasi yun, publish nga siya, and the purpose is that so that everyone will know if they are infringing, or if it's already existing. And one of the ayun, as discussed in the presentation a while ago, those things that can make the application as a prior art, or there is already a question of an existing prior art, no, that will you know, it will override the certain application that will not warrant its application, parang detrimental to its application. Yun yung mga apat na I think I gave for certain examples that could destroy the novelty of the application, and not just novelty, even during the publication. So the inventiveness can also be questioned. So there is a certain period of in the application process where this thing can happen.
Thank you so much, sir. And I would like also to announce, guys, that we are encouraging you all, if you have still some questions, you can feel free to drop it or type it in our chat box, because we will be happy to accommodate your questions immediately. So I guess we're ready to move for the next question. So this is addressed for Professor Kenneth. So the question, sir, is in filing an application for patent, it will undergo two different tests such as novelty, inventiveness, and etc. So for sure that the patent will not be granted instantly, as it will take time. See, for example, someone used an innovation which is still under evaluation for patent grant without owner's authorization. So is the person who used one's innovation will receive penalty, or just right after the patent is granted?
Okay, thank you. Very, very good question. So basically, once you applied for patent, as the one applying for it, you get the priority date, di ba? So kasi your protection naman starts from the filing date. So yun yung parang scope of protection mo from the filing date to 20 years later. That is if your application is granted. Now, by the way, application for patent usually takes around 5 years, 3 to 5 years for it to be granted. So in that period of time, yeah, this could happen that someone might be already using your innovation or your invention, and and at that moment you still don't have the authority because you don't own the patent at the moment, diba? I mean, your patent is not yet granted. So what you can actually do is to inform the person na, hey, there is an ongoing application for this, and you have to stop, or whatever negotiation that you want to use, or you can at least you have informed already the person who is using the invention. So because later on, once your patent is granted and you have now the ownership, so you have now the bragging right, I'm really indeed the owner because my patent has been granted by Ipofil. So you can go after the one using it and even allow him to pay for using your work from the moment he was using it, even before you have received your patent, as long as because you have already informed the person even. So yun, I think I hope I have answered their questions.
Yes, sir. Thank you so much, sir. May I know, Engineer Jeffrey and Engineer Lawrence, if you have something to add?
Yeah, siguro the jointer, no? So there will be two sides of this story. No, so the one is the question about you using the technology, or you're the technology creator. No, so Kenneth presented the other party, no. So if you're an owner of a technology as well, no, so this is the time that you really have to think about and decide how strong is your the position of your patent, no. So that means to say that if you're confident enough, that the patent will be granted to you, and then people actually began commercializing. They begin commercializing, introducing their product to the market. The moment that the patent is already applied, that means that you have the priority date, as mentioned by Kenneth. And the thing is that when they commercialize the product, that's why you see on the product labels patent pending. So those are actually products that are not yet been granted. So if you're the owner of that, so I guess you have to be very careful, in terms of the product that you're selling as well. No? So how easy the product can be reproduced. No? So para dali lang ba siya i-reproduce? So because if you're not confident with your patent application, so it will end up also na you might not be getting the patent after all, no, if you don't pass the patentability requirements, and in that case, so you don't get the protection that you need, no. So and then the product will become an open season, because everybody can copy now. And I think the advice that we want to provide is that when you commercialize this type of product, even if you get or you don't get the product, you have to position that if this is a startup company or even a branded company already, the branding of the product needs to be established very, very strong. So that even if the product is there in the market now, so you've built a brand already, and then people will go to you, not because you have patent, but because you have a very strong brand. I think that's one of the areas that you can go to. So branding, no, and branding in terms of the product, making known that the product has really like established good value, no, so good value proposition, and then you still maintain, no, the market even if you have competitors already like trying to parang copycat, no, your product. It's just like the suka pinakurat case. No, so there are a lot of suka pinakurat out there right now, di ba? But the suka pinakurat has built a very strong brand, and copycats try to follow it, and yet people still get the brand, no, the suka pinakurat, because they're first in the market and they build a very strong brand. So I think that's one of the the other perspective. Thank you for that very good question.
If I may add also in another perspective,
Yes, sir.
maybe just to clarify na actually once you have applied for patent, um, but I mean, this is just sort of an encouragement. Why do you need to really apply for patent right away once you have that technology? No, you have developed a technology, because the protection again is inherent even from the moment of your filing. So parang kasi many of the patent applicants are afraid of disclosing their invention, kasi once ma-disclose niya siya sa public, somebody else might be able to use it, diba? So parang yun yung fear nila. But again, there is an inherent right already given to the patent applicant na even if your patent is not yet been granted, ayun, considering that you are very much confident that it will be granted later on, no, that's how confident you are, then don't worry, because the right given to you is parang inherent at the moment you apply for the filing date. So ayun, so don't worry about others might be using your innovation while the application is still ongoing, because ayun, as I have mentioned a while ago, uh, right at the moment you have received your patent, you can go after those people who are uh, violently or unauthorizedly using your work. Ayan, thank you.
Thank you so much, sir. Is Engineer Lawrence has something to add, sir? Hello, sir.
Sir, I think all of those things are already said by those speakers. So that's right, no. So when the patent is granted, that is the time that it has the right is enforced. So although the hello. Okay. Although you have to wait for the patent to be granted, you are you don't need to worry because once it is granted, the full enforcement is within the kuan. So ma-protected siya.
All right. Thank you so much, Engineer Jeffrey, Engineer Lawrence, and Professor Kenneth. Thank you so much, sir, for addressing this question. And we're really speechless right now, sir, for all your answers.
I'm just surprised that we ended the lectures very soon. so when I came back, Lawrence is already done. No? So I think we've done a good job to shorten our presentation today.
Namawi, sir, namawi.
Summarize.
Yes, sir. Thank you so much once again, sir. So we proceed now to our next question. So next slide, please. So this is addressed for Engineer Lawrence. Hi, sir. So the question is, two different persons work equally for an innovative work and then later apply for patent. Unluckily, the patent was granted. If later these two persons have conflict with each other related to their patent, who do you think is more rightful for the patent?
I want to clarify if both of them are the owner of the patent. Tama?
May I request? Yes, sir. Yes, sir. Both of them, daw, sir.
So assuming the patent is named after them as owner. So I'm not sure, but in my opinion, I think they have the equal rights when it comes to the as the owner of the patent. It is not, I think, sir, di ba? There is no something sharing, or I think it is an equal sharing when it comes to the owner of the patent. Tama ba, sir? No?
Yeah. Yeah. So tama to gisulti ni Sir Lawrence. So there was no prior arrangement, so that means that the ownership of the patent belongs the same, no, exact, like equally, no, to the two persons, no. So unless if there is like prior arrangement, a document other than the ownership, no, so like there is arrangement that, okay, example, the three of us, si Kenneth, Lawrence own the patent, and we say, si Lawrence man ang project leader, so he gets to have like 60% of that, and then 40%, 2020, so mahilig kami sa 60-40, you know, so may reason yan. So 2020, so if there is a prior agreement with that, maybe that will have a, when we go to court later on, might have a teeth, no, kung merong agreement. So actually the basis, yeah, so I think we'll not expand on that, no, but yeah, so for this I think for this case, so they have equal rights, no, they have equal
default
rights.
To sir, default.
Yeah, by default. Yeah.
All right. Thank you so much, sir. Thank you so much, Engineer Jeffrey and Engineer Lawrence. May I know, Sir Kenneth, if you have something to add, sir?
I think that's the answer, definite answer already.
Okay, sir. Thank you so much, sir. And now we proceed for our next question. Next slide, please. So this is for Engineer Deliosa. Can an innovation still considered patentable if it was published or displayed to public right before the filing date?
I think this was covered in the lecture ni Sir Kenneth kagahapon. Sir Ken.
Yeah, this also this afternoon.
Also this afternoon. So
yes.
Sir Ken.
I've shared I think, yeah, if I'm not mistaken, four icons there a while ago, matters that can destroy the novelty of the application. There are different forms of disclosure that affects your application because it will form part of prior art. It will become a prior art already once it is published. Even if the patent applicant itself is the one who published it, the more the more there's a problem because it will reflect exactly the same technology disclosure. So again, any form, even oral disclosure, is part of detrimental form that will make your technology a prior art. But again, there is a qualifying term that I use there, as long as it is a substantial disclosure. So, once the disclosure is sufficient enough to really make it available to a person skilled in the art to figure out what you have done, then patay ka, lagot ka. It would be difficult to, traverse your application for patent. Yun.
All right. Thank you so much, sir. This is a good question and able to recall for our yesterday's discussion. So I guess we're ready for the next question. So this is for Engineer Lawrence. So an interested our participants, please don't mute your mic and please don't talk. All right. So this question is for Engineer Lauren. So the question is, can an interested party file an action for the cancellation of the patent? Is this question is balik na?
It's already questioned.
All right. So I'm sorry, sir. So this question is for Professor Kenneth. So the question is, to enjoy the benefit of your rights as an innovator in terms of intellectual property, one innovator must apply for apply for patent search. In terms of financial difficulties, can a person sell or his or her patent?
So what's the premise here? The patent is already granted, or what?
Yes, sir.
Granted na.
Yes, sir.
Okay. Yes, your patent right can actually be transferred, can also be licensed, can also be leased. So parang it's really like any property. Now, whatever you can do to your land, to your house, you can do the same with IP, your IPR.
All right.
So, by
Thank you
the
so
way,
much, sir.
for patent search, you don't have to apply for patent search. As I have mentioned in this webinar, you yourself can actually conduct a patent search. So, anyone can do the patent search. Only that during the application, if not yet granted, we are still talking on during the application. The examiner will also conduct its own patent search activity, and that's when you compete in your capacity to do the patent search, kasi meron din silang ibang database, no, usually commercial siguro yung ginagamit nila, and ayun, how efficient your patent searching is. So yun, magko-compete kayo, mag-a-analyze kayo na you will try to prove that your work is indeed new, while the examiner will do otherwise. Parang naghanap siya ng proof talaga na you could surpass the requirements, the criteria, yung novelty and inventiveness. Yun, parang ano yan talaga, exchanging of results, ayan, and discussions.
All right, sir. Thank you, sir. Sir, someone chatted, sir, na mishap daw ang term nga patent search dapat apply for patent na.
Yeah. So that's it. So for the next question, or for the main question, ayun, the answer is yes, no. Since you already own, assuming no, I mean granting that you already own the patent, so you can do whatever you want, no, even transfer, sell, lease, uh, uh, license, no, yun, just like any other property.
Yes, thank you so much, sir. May I know, I mean, Engineer Jeffrey and Engineer Lawrence, if you have something to add, sir?
Yeah, siguro, sige Renz, sige Renz.
Okay na ka to, sir.
Yeah, siguro in addition lang, no, so we also want to clarify that it's not exclusive, no, that the ITSO personnel, the ITSO technical expert, baka madlock mo no nga, technical expert lang ang maka-file o patent application. No? It's not. So that's why what we're trying to do really is educate the researchers, even you, the students, no, can write your own patent application. So, but basically we always advise, no, that we start with the patent search. Napa ba ko? Murag na freeze man ko. Napa ba ko? Nawala akong internet. My internet connection daw is unstable. So I'll just turn off my video now. So this is one of the things na among ginahimo sa office na. So we want students, faculty members to learn patent search so that really they can do the work now, because there are a lot of people, there are a lot of innovators, and we're trying to also transfer our learnings to you guys so that you can also do this thing for your innovation. No? So do patent search yourself, you analyze it. So with mentorship siguro, no? And then later on, if you're ready, we can also teach you how to draft patents. So that's what we want to do actually. No, that you guys, when you finish your technologies later on, you can draft your own patents and then you can apply it, no, for your innovations. So I think that's what I want to also highlight, no, in addition to this. In terms of selling, I think Kenneth has provided you all the answers.
All right, thank you so much, Professor Kenneth and Engineer Jeffrey. We really appreciate your effort and time, sir. So I guess we are ready to move for the next question. And also, guys, I would like also to announce that the evaluation form will be available right after the closing remarks. So please stay with us and enjoy listening. So for the next question this is for Engineer Deliosa. So the question is, as mentioned in the lecture, novelty is one of the requirements to obtain the right for intellectual property for an innovative work. As a student or individual with innovative wait. So again, as a student or individual with innovative thinking and works, searching online is most convenient way to examine if my innovation is novel. And several online searching tool was mentioned. Among those mentioned free searching tool, what can you recommend as the best searching tool?
So medyo mahaba, no, pang Miss Universe dates, but very good question, no. So I'm very happy that you guys always give us difficult questions. so basically, our team, especially our technical experts, are using so it's not for free, no. So that's a Thomson Reuters. So but for free, so we always go to the most established one, like the patent scope of WIPO and the European Patent Office. I think I also mentioned US Patent Office. Pero based on our experience, I for myself, no, so it's easy to navigate the patent scope, the WIPO, and the EPO. Mas difficult pa nga i-navigate yung Philippine. Ay, sorry. I pupil na.
Naka-record, sir. Naka-record.
Naka-record. Ay, sorry. Admittedly, I always like aspire, no, for IPOFIL to make the database of IPOFIL better, no. Google is one thing, but sometimes there are problems with the Google patent search. So for authoritative database, free, go for the patent scope and ESPASnet. I think Kenneth and Lawrence can also advise you. No?
Yes, sir. Same database, sir. In my experience, it is also best to use the SPASnet, Patent Scope, and Google Patent. But basically, all of those database are very good naman. So for the IPOPIL patent search, medyo limited yung ano niya, yung scope niya.
Entries. Naka-record ka, Lawrence, ha?
So for me, my top 3 I think is SPASnet, next is Patent Scope, then Google Patent.
May taga-IPOPIL ba dito?
If I may also answer. In my presentation, I actually mentioned, I agree with Sir Jeff and Sir Lawrence, no, na parang when it comes to the ease of use, those big 3 are actually very very good, no, very wonderful, because the interface is easy to follow and all that, the features. But as I have mentioned in the presentation, because these three, I don't know how to call it, hindi naman group organizations. So let's say these 3 organizations are actually parang independent in nature. Parang they have their own team working on collecting of various patent documents all around the world independently. So that is why it's actually we cannot definitely say that one is better than the other, because it depends on the kind of patent or technology that you are looking at or looking for. So it depends on that, because sometimes using a certain keyword, for example, as I have given an example, this one might give you a lot of results while the other does not. But if you look for another kind of keywords, so it might be a different result. So parang it's all like that. But when it comes to the ease of use, yun. So the big 3, I think are very much very wonderful to use. Actually, meron pa ngang free patent Meron ding freepatent.com ba yun? It's also very easy, just like Google Patent. So
FTO, Free
ayun.
Patent Online.
Yeah, free patent online. Ayan, thank you, sir.
All right. Thank you so much, Professor Kenneth, Engineer Jeffrey, and Engineer Lawrence. Thank you so much, sir, for addressing this question. So I guess we are ready to proceed. University, Pampanga State Agricultural University, Visayas State University, Central Bicol State University of Agriculture, University of the Philippines, Los Baños, Don Mariano Marcos Memorial State University, and Mindanao State University, Maguindanao Campus. Thank you, everyone, and we will still have some parts left in our program. So we really appreciate you guys for being with us today, because I know that all of you have some silent battles and also have upcoming exams and quizzes. So we really appreciate your effort despite of all the hectic schedules that you have. So thank you so much, everyone. And I hope that you really learned a lot and enjoy this program. So are you all ready for the next part of the program? So this time, we are proceed for the next part of the program is the presentation of certificates for our resource speakers. So may I read to you the content of the certificate? Caraga State University College of Engineering and Geosciences, Department of Agricultural and Biosystems Engineering, Certificate of Appreciation. This certificate is presented to Engineer Jeffrey T. Deliosa, an Electronics and Communication Engineer, for his invaluable insights, experiences, and expertise shared with the participants of the webinar series entitled Basics of Patent Search, Drafting, and Application of Process, Patent Information Search, and Type of Patent Searches. So this held on July 7, 2021 via Zoom and FB Live platforms. Given the 7th day of July 2021 at Caraga State University, Ampayun, Butuan City, Philippines, signed by Kenneth M. Poyles, Agricultural and Biosystems Engineering Student Society President, and signed by Engineer Philip Donald C. Sanchez, current Chairperson of Department of Agricultural and Biosystems Engineering in Caraga State University, and also signed by Professor Engineer Miriam M. Santillan, the College Dean of College of Engineering and Geosciences. Thank you so much, Engineer Jeffrey Deliosa, for being one of our resource speakers for today. So thank you so much, sir.
Yeah, thank you po kayo, Kenneth. And you're welcome.
Yes, sir. We're grateful, sir, for your presence.
Thank you sa mga Kenneth.
So for the second certificate is awarded to Professor Kenneth L. Shadad, and registered chemist. So thank you so much, Professor Kenneth. Really appreciate, sir, your effort and time and your dedication in able to impart your knowledge with us, sir. Thank you so much, sir. And we hope that we can acquire those knowledge in real life situations, sir. Thank you so much, sir. And now for the
always feel free to contact us now if you have clarifications.
Yes, sir. Thank you so much, sir. We really appreciate, sir. So for our third certificate is awarded to Engineer Lawrence P. Grana. Thank you so much, Engineer, for your time and effort, sir, and all the knowledge, those constructive and informative insights that you have shared with us today. Thank you so much, sir, Engineer Grana. And we hope to our resource speakers that to see you soon when this pandemic is over. Thank you so much. And we're really grateful for having you all as our resource speakers. Thank you so much, Engineer Lawrence P. Grana.
Thank you. Thank you.
And now for the next part of the program is the closing remarks. So I believe that this is one of the segment of the program is you all waited for. So help me welcome, guys. Help me welcome again, guys, for our closing remarks, Miss Shiva May, our October, the Agricultural and Biosystems Engineering student of Caraga State University.
Ladies and gentlemen, I believe that all of you have well done through a 2-day webinar series of ABE 197. It is my great pleasure that you had a fruitful discussion, though I think 2 days is really not enough. In behalf of the Department of Agricultural and Biosystems Engineering, I would like to express my gratitude to our speakers, Engineer Deliosa, Professor Shadad, and Engineer Grana, who shared their expertise and knowledge for our time-relevant topics that us participants can benefit. They highlighted the opportunities and benefits that the participants can use in their future projects and innovations. And to all our participants, thank you so much for taking your time to attend this webinar, for the passion and dedication that you have shown. Before I end my closing remarks, I would like to convey a special thanks to the people behind this activity. Thank you so much for your priceless contributions, for running this event smoothly, and for making this activity possible. Thank you, everyone. Stay safe and may God bless us all.
All right, thank you, Ate Shiva. This would be successful without the dedication of our very own, the current chairperson of Agricultural and Biosystems Engineering in Caraga State University. Thank you so much, Engineer Philip Donald C. Sanchez. Thank you so much, sir, for this opportunity. And this is a great avenue for all your students, sir, to improve and to add more insights. So me we request everyone to open your camera for our photo op. So this is our remembrance, guys. So we are encouraging you all to open your camera for our photo op. Don't be shy, everyone. You are really welcome for this program and really appreciate your presence. And we hope that you will able to succeed and nail your exams and quizzes. So is everyone is opening their cameras? Ate Shiva? All right, so Engineer Philip will doing the screenshot. So are you all ready? So 1, 2, 3, smile. All right, one last. Okay, next. 1, 2, 3, smile.
Ito ni ba? Ito ni Lopte. Sa tubig yun.
All right, one last time. 1, 2, 3, smile.
Burnout kaya pa sa'yo mo si tangad to?
All right, there you have it, guys. So thank you everyone for participating and joining us again. Thank you so much, everyone. And we're really grateful for this opportunity and for your presence. Thank you so much once again. So in behalf of the people behind this event, I would like to thank Marjon Alvarado, Miss Ate Shiva, and Kuya Jason, and Miss Hanivet Arrogancia, and also to Kenneth M. Boyles, and also to our layout artist, James Kular. Thank you so much, everyone, and congratulations for this successful event. So we are really happy and grateful for this opportunity. So this is really rare, and the semester is almost over. So all right, the evaluation form, guys, is already now available in our chat box. So you can now, or right after this program, you can now answer your evaluation forms. Once again, thank you so much, Engineer Philip. Engineer Philip, thank you so much to our faculty in DABE. Thank you so much to all your support, and also to our Dean in College of Engineering and Geosciences. Thank you so much, everyone. And also to our resource speakers, once again, thank you so much, Engineer Jeffrey, Engineer Lawrence, and Professor Kenneth. Thank you so much, everyone, and we hope to see you soon, and stay safe. So I guess this is just not the end, but also the start of a new endeavor for acquiring those insights that you have learned along those webinar series that happened. So stay safe, everyone. And a round of applause to all people behind this event. Thank you so much, everyone. To Engineer Philip Donald C. Sanchez, thank you so much, sir. All right, so shout out to all agricultural and biosystems engineering students in Caraga State University. Thank you, everyone, and God bless in your exams, quizzes, and finals. So this semester is almost over, and we hope to see you soon.
See you.
All
Congratulations.
right, once again, the chat in our chat box. So once again, the evaluation form is already available in our chat box. So you can now answer the evaluation form and able to receive another certificate for today's webinar series. So there's another shout out to all third year students taking up Bachelor of Science in Agricultural and Biosystems Engineering. Hi everyone, hi our bayos from different universities and colleges across the country. Once again, congratulations to the people behind this event for this successful program and presentation and all. This is a very great opportunity for all of us. Thank you so much. And this will not feasible without the help of Sir Philip. Thank you so much, sir. So there's another shout out. So this is from Genevieve Poliran. So single daw siya, guys. And also to Jaja Dayok.
Shout out,
So,
Kenneth.
Is it to?
Shout out.
Kinsa to?
Hey, Ken.
So, hi.
Boy love.
Si Puliran.
So there's another shout out. Shout out to Rica Bautista. Hi, Rica. From Marjon.
Hey.
Also, we would like to extend our gratitude to Genevieve Puliran, who's doing her job, enable for us to live on Facebook. Thank you, Genevieve.
Welcome, Ken.
Sige, urag na conscious naman sila nga naapata, Sir Jeff. Anyway, thank you, Ken. Congratulations.
Yes, thank
for
you so
this.
much, sir.
So
And
I will
stay
leave
safe.
ahead. Sir Jeff, I will ahead. Urag na conscious man sila. But I think Sir Jeff has to stay because he's the host. So,
Thank you so much, sir.
Yeah,
And
I'm
I-
okay to stay. Congratulations, guys, Kenneth, and the rest of the
Thank you so much, sir.
officers, no, for leading and for this successful today event. And
yeah.
our team, I'd like to thank also Kenneth and Engineer Lawrence, no, for really giving their best no, in the presentation and in the question and answer. You guys ask difficult questions. So thank you, everyone.
Unexpected questions.
Yeah, very good questions actually. So
Sir.
so keep it coming.
Thank you also to Marjon.
It's because they're the intelligent group as well, Ken. That's why they ask tough questions.
Thank you, sir. Unta okay lang tong shout out, sir.
Yeah,
Thank
okay
you,
lang. I think somebody asked you,
Daghang fans si
if
Kenneth,
you're-
sir. Daghang fans.
if you're still binata.
Thank you, sirs.
Sheva,
Thank you,
Sheva
kayo.
May, thank you for the assistance.
Shiva, thank you for sa mga naghatag closing remarks and opening remarks. Be brilliant, brilliant.
Yeah, we hope to see you guys not through the online or maybe in the future. We can do this event or something like this in the future.
Yes, sir. We're looking forward.
Soon, sir.
Sige. Wala ka na dyan ko, Sir Jeff, ha?
Ken, thank you, Ken. Bye-bye. I think
Thank you,
Thank you so
everyone.
much, Professor Kenneth and Engineer
Thank you.
Jeffrey. Thank you so much, sir.
Jeff.
And to Engineer Lawrence, thank you so much, sir.
Yeah, we enjoyed it as well. Thank you, guys.
Thank you to all participants. Thank you so much, and God bless.
Thank you, everyone.